present before you all a brief introduction of the eminent speaker in our midst today. Dr. Ravindra Pratap has the distinction of obtaining bachelor's in law from one of the oldest universities established in the Indian subcontinent, that is Allahabad University. He received gold medal for his MA Political Science from the same university. He obtained LLM degree in European Business Law jointly from the universities of Barcelona, Spain, Bologna, Italy, Essex, UK, Constance, Germany, Louis Guido Cali, Italy, Jean Moulin, Leon, France, and Nîmes, the Netherlands. He did his PhD in World Trade Law from the Jawaharlal Nehru University, and his thesis is titled India and the WTO Dispute Settlement System. His areas of specializations are public international law and international trade law. Some of the main courses that he has taken up include interpretation of statutes, intellectual property rights, international humanitarian law, and others. He has authored 2 books titled Interpretation of Statutes, a reader that came out in 2010, and India at the WTO Dispute Settlement System that came out in 2004. He has various research papers, articles, and chapters in different books to his credit. Some of the recent ones are DSU Reforms, the Soto Report that got published in the Indian Journal of International Law in 2011, India, WTO and Shrimp Settle that got published in the Indian Journal of International Law in 2010, International Humanitarian Law, India's Attitude that got published in a book that was edited by Mani, International Humanitarian Law in South Asia, which is actually from an Oxford University publication, History of European Peace Treaties Practice, and various others. It is an honor to have you in our company today, sir. I welcome you to our university and extend my best wishes to you. I also wish the student fraternity an enriching experience during the course of these lecture series. In the end, I leave you all with an interesting thought by Molly Evans. I believe ignorance is the root of all evils and that no one knows the truth. Thank you. Now I would like to call upon the speaker. Thank you so much.
Hello. Thank you very much, Mr. for very kind words, and thank you very much, Mr. Tyagi, for inviting me to speak to young students from a number of countries on a subject which remains as fascinating as interpretation, legal interpretation. Indeed, it is a very difficult subject in the sense that this is not about a particular branch of law. It actually assimilates in almost all branches of law where there is written law. That is the first preliminary point thought that comes to my mind. The second point is this. This is a gathering which comes from not just one AUC jurisdiction. It comes from several jurisdictions, although I can find a number of commonalities, say, in the countries that we have in South Asia. However, it is very important to know. I would like this talk to be the first, because this is an introductory talk. I would like to have your experience with me first. So I have 2 questions for you. The first question is that what have you learned on interaction and interpretation, legal interpretation at your graduation level? And the second question is, what are your expectations for the series of lectures that will follow? Because I know, at least from my experience from Indian universities, that this is a subject which is taught in almost all universities at the graduate level, called the interpretation of statute. Recently, in 2008, the Bar Council of India has revised and made it interpretation of statute and principles of legislation. I'm not aware whether any university has, reformulated the syllabus, which remains essentially the same as it was for the interpretation of statute. Just very quickly, because I've already forwarded to you some basic readings for this background class, so that is for the half of the class, and in the next 1 hour. So first I would like to have your, what did you study? From Indian, you see 1 or 2 Indians, students studied in universities, or I should presume, if you don't tell me, I would like other students from other countries to let me know. Because I've seen some judgments, you see, from the jurisdictions such as Sri Lanka and Pakistan, the Supreme Court judgments, where the courts of these, the Supreme Courts of these 2 countries at least, have resorted to the means of the kinds of interpretation which Indian Supreme Court would do, or historically the Commonwealth countries, you see, have been doing. Just very quickly, yes please.
So during graduation we studied the different rules of interpretation.
Okay.
And then about the role of important segments of a statute.
Okay.
Preamble, what's the relevance, and how is it relevant in interpreting that statute, then object law, all the provisions.
So you have studied the parts of legislation. That
and
is
the rules of interpretation of statutes.
Okay. Rules, which rules you have studied?
Golden rule,
Okay.
all these things.
Golden rules you have studied. Any other reaction? Any other, you see, student from any Indian university? Delhi University student? Is there anyone here from Delhi University, faculty of law? Yes. What did you do for your interpretation?
Pretty similar to what you shared.
Okay. Golden rule you studied.
Yeah. I studied very long ago actually, sir.
Strict interpretation you studied. Liberal interpretation you studied.
Yes, sir.
Isn't it? Cadence rules you also studied. Okay.
Rules of construction.
Rules of construction. Construction or constructions. Interpretation.
Yes.
Different from interpretation. Okay.
External
Harmonious construction, not harmonious interpretation. Construction. Yes.
Doctrine of colorable legislation.
And
Doctrine of colorable legislation.
okay. Doctrine of colorable legislation. The doctrine of pitch and substance. And what else?
External and internal aids.
External and internal aids to interpretation. Yes. What else?
Civil and various doctrines, for example, adjective genders, satire of surprise.
Okay. Are these different from internal rules of interpretation?
No, sir.
Part of it.
These are part of it.
Okay. What else? Have you studied the Vienna Convention of the Law of Treaties
Yes, sir.
as part of legal interpretation?
No, sir.
That is where lies the problem. Students of LLB are necessarily studying international law, at least as an optional subject. They also study alongside a separate subject called interpretation of statute or principle of legislation alongside it. But they do not study the Vienna Convention on the Law of Treaties. That is, at least to my mind, the only codified rules of interpretation at the international level. I do not have a ready-made inventory of many a decision of the Indian Supreme Court where I could say that these rules have been relied on. Indeed, I do not have even one where these rules have been resorted to in the interpretation of the law, but I am certainly aware of a number of judgments from different jurisdictions outside of India, and also of the International Organization of the Inter-American Court of Human Rights, where indeed in the Alpha report, the latest case of Inter-American Court of Human Rights in 2012, April 2012, these rules have been preferred. Let me, you see, after having this first preliminary point where I have gathered some information, let me make a first general observation. The first preliminary observation is, whereas interpretation remains essentially a judicial function, also of national courts, certainly of superior courts, the methods of resolving interpretive problems have been very different at national level and at international level. This terminology, this basically is the difference. A treaty, when it is part of domestic law for the purposes of the higher judiciary and also for the citizens deriving rights under that particular treaty, which has already become part of domestic law, actually is not different from the domestic law when you go before the court in the writ petition. If the treaty which has been adopted, negotiated in a manner in which treaties are negotiated in terms of the Vienna Convention, adopted, entered into force, and when they are applied as part of the municipal law, the system of interpretation is absolutely different in the national jurisdiction. That is basically the first point that you find. The gap between the processes of interpretation at the national level and at the international. That is the first point that you find in almost all. The second, you see, tendency is once a decision has been given on a particular subject, I'm sure almost all South Asian countries, I'm not aware of any jurisdiction which is not aware of the doctrine of stare decisis. That is the doctrine of precedent. So once a decision has been given, in a later case, the lawyers do not cite statutes, they cite cases. So the difference is that you have a case such as Bhawan case, in which two judges of the Supreme Court, in fact 3 judges of the Supreme Court, disagree as to what the other judge has said. Whereas the judgment is cited as a very good judgment on the doctrine of stare decisis. My question is, if the judges themselves who are part of the decision, they do not agree as to what the fellow brother has said, what is going to be the case for the litigant? What the ratio, what that elusive ratio would you discern from these judgments, where it is absolutely not clear? I hope you see, you read Bhawan case, but I am referring you to Bhawan, the 1980 case, which was very well relied on in a case that went to the Supreme Court of India in 2007. 11th January, if I correctly remember, that was decided IR Coelho case. The question was, the court itself was not clear as to what was before the court in Kesavdanda Bharati case, whether a point on which lawyers were arguing, litigants were arguing that you see, it was a stare decisis. They were not clear. The question is, if a point was never subjected to litigation, if no claim had been made, and even if there was an observation on a point of law, it is the point on which there can be no ratio. Very elementary, you see, elementary points on ratio decisis, or whatever ratio decidedly is, everybody would agree. It will come to the contentious point. You must have to have the facts before the court. If If there was no relevant fact before the court, any observation by the court would not form part of the ratio. So this is basically the difficulty. You have one case becoming the ratio for the other case. So in the next case, the statute is not law. It is the decision. So it is basically, in a sense, undermining of the statute law. A judgment can at best explain, but only at worst substitute a statute. This is to me the second point I want to make. The third point that I wanted to make is it is obviously a business for the court to decide cases. If only it is compulsory many a time for people to go to the court. They have to decide. But obviously we are not litigants. Certainly we are not interested in everyday decisions that come. We are interested in decisions such as the one that I forwarded to you. I am not sure whether you have read that decision, Brown versus Board of Education. I am sure everybody must have heard this judgment even without reading it. We will have the chance to read this judgment. Do you find anything new in this? What do you find in this judgment? Why is this judgment is not like any other judgment? Why was it not followed in that particular case? It had been the same statute, the same constitution, the same amendment, had been followed in a number of cases before. Why was it not? What did change? What change had undergone? Was it possible for Chief Justice Bhawan to give the same judgment if he had not, in the circumstances, read the 14th Amendment? If he had merely read those lines of precedents, there were a number of them. I think, if I am not incorrect, it's 6. So this is basically the third point that I am saying. Some of these judgments that you find, these are totally different because they do not decide cases. Certainly they do, but they do more than that. They do more than that. The very ratio, can you tell me the ratio of this case? Brown versus Board of Education. Let me ask, some of you have read this because you are saying it. Let me ask you, what was the ratio? The so-called ratio, you know it from Professor Goodhart's very long old thesis of this ratio on the relevant facts doctrine. What was the ratio? The ratio of the case was separate but equal. Doctrine is inherently unconstitutional. The ratio was the fact that similarly placed persons were treated separately ends up the point. The constitutional inquiry doesn't go beyond whether they were not treated unfairly, because the fact that they were treated separately was unfair enough not to survive the test of unconstitutional. That is the fact that you are asking separate. It's like that. If we have a separate classroom and find out some students who sit there and you say you also have the same PC, you have the same speaker, you have all kinds of facilities. So what is the problem? Question is, if you separate, similarly place, you see persons, and even if you give them equal treatment, that was the catch in all the 6 judgments I had. The argument was, what is unequal? They are given equal treatment. Warren said,
The fact that you have separated them and the matter. You don't have to go beyond that. So this is, you see, just not just one, you see, judgment in the due course of other lectures I would forward to you and would like, but I would really expect you to be more participating, you see, than what you are doing today. For instance, judgment will be much longer than this and equally fast-breaking. Some of the best known judgments in the history, such as Roe versus Wade, 1973, and you see a decision of the American Supreme Court that will
Abortion law. Abortion law.
Abortion law. You see, is a landmark. It is a super precedent. I am not aware of a better precedent in America which was challenged as many times, and every time it was challenged, it should survive the test. Every time it gets even stronger and stronger. Now, similarly, when you come, let me get back to the point where I began. So there is what we find, whereas the subject remains, you see, with students. In methodology that we follow to pursue this subject is essentially, you see, different, and I find no convincing reasons, at least for LLM students, and I am aware that I am not speaking to LLM students. Had it been otherwise, I would probably have not been so inclined in my viewpoint that I am. There is no need. I can understand people who end up with legal education after LLM, it means that they would end up with court. I think it is better if you cite those, you cite literal rule one day, tomorrow you call it a golden rule, and third day you call that literal rule has been given a go right, and fourth day you say, if I say pencil, it means pencil, it is not a donkey or a horse. So these kinds of oversimplification. But this is not an LLB class. You have come to LLM. I am sure they have different things in mind, at least for now. They are not going to end up in court. There is no need to again study those golden rules. No need to study those little rules. Wherever you study, you study at least in a manner in which it does justice to the discipline that it is part of, that is legal interpretation. The fourth point, you see, I had forwarded to you the text of the United Nations Charter. You must have seen this is the original text which I got from the UN, some of the UN references, because you find some signatures there. If you notice that, this is the original charter which was signed by countries including India, one EP Kismachari. We are signed it. So that text is also here. Anyone here who has not read the charter, some part of it, or who would not understand, you see, the significance of charter in relation to legal interpretation? Any law point, any case law which you have had occasion of referring to on charter law? Anyone? No case? Has anyone studied a case on charter of the United Nations in relation to legal interpretation? Okay. Because this will actually facilitate me in choosing material and doing this later in class. Any secondary sources? What secondary sources? I told you understand secondary sources. Yes. Any secondary source which means books, articles on interpretation of a statute, indeed it was the subject, there will be level or any other subject that you have studied. I am
sure Supreme Court of Sri Lanka. Is there anyone here from Sri Lanka? Yes. Supreme Court of Sri Lanka very closely refers to Indian Supreme Court. And I'll forward to a case where you find, you see, more Indian cases was cited than Sri Lanka. They very closely follow. And in terms of, you see, the academic content and systematic way of presentation of the case, I find Sri Lankan judgments, whatever little that I could go through, than judgments from Pakistan. More systematic in approach. But ultimately they do not go beyond the framework of the mindset of Indian way of approaching interpretation properly. Any secondary material that I go through. So that is very important. Any secondary material that you have studied. Any secondary material on the Charter of the United Nations that you study. So that I can have some idea of what the effort is Bruno Sima, Charter of the United Nations. So this is a commentary on Article of the Charter by our distinguished judge of the United States, What else? Have you studied Hans Kelsen? Yes, sir. Yes. I am grateful to Professor Jaggi who asked me to read when I was in school Hans Kelsen. And I also studied, had occasion to find in the JU library 2 books written by 2 former students of Professor Kelsen. And you know what they have written there? Kelsen wrote an incomplete commentary of the Charter. Sir, am I correct? But he said, they said, that incomplete commentary is unparalleled. Nobody could complete it at the level at which Kelsen left it incomplete. So, Hans Kelsen is marvelous. Whether it is pure theory of law, look at this command over jurisprudence. Sometimes students believe that jurisprudence is a subject which must be left to the professors who have nothing else to do but to talk. And people who have something to do should do IPC, should do CRPC or something like that. But let me tell you, I recall of very distinguished professor, Professor Harold Lasky, who wrote a book called A Grammar of Politics. And he said something about jurisprudence. And what he said is, it's instructive for those who believe this subject, you see it to be a subject which not everyone, every law student. And what he said, and I quote Professor Lasky, that jurisprudence is the eye of the law. It gives the law its insight into the environment of which it is the expression. It relates the law to the spirit of time. And the richer the jurisprudence of a system in a given era, the nearer will be the law of that system to the needs of its time. Unquote. So, you can see Hans Kelsen. The question is the point I am making is this. If a particular problem does not find its solution, it has enumerated list of solutions such as the statutes and provisions of law, it will get, if at all it is going to get, a solution is jurisprudence. It basically completes the cycle of the reservoir of legal solutions, without which, no matter how many references you have. Cardozo, I said it. Cardozo was a judge. In the nature of the judicial process, he said, and I quote a sentence from it, nature of the judicial process. If that was all for our colleague, references, a man with the best reference would be the best judge. But when references fail, lights do not mix, colors do not match, only then the serious business of a judge begins. So he said it.
even if so well versed in number of judgment statutes and interpretation, even judges will find it difficult always to find ready-made solutions to the problems arising out of new facts. Rousseau found that in his Philosophy of Law, chapter 3, no two cases are alike, nor will ever be alike. Therefore, the law is the same. When you file a petition, next day amendment is not introduced. It is there. So therefore, it is basically some creativity, some novelty is inherent in the judicial process. But the line between lawmaking and interpretation, no matter how thin the line might sound, is the line which must be maintained. Frankfurter, you see, writing in 1949 or 8 in Columbia Law Review, that certain you see reflections on the reading of statute. There exists a line between legislation and interpretation. We do not know because this is not visible. You can't take a picture of it through your mobile camera. But it must be a trained willingness and instinctiveness of a judge never to try and let it. The point is not that he doesn't. Many a time he has not. So these are a couple of few meetings that you have. I would say we will have to make use of these readings. I will give you references. Starting with, I would say you read Theory of Legal Interpretation by Oliver Wendell Holmes, Harvard Law Review, Volume 10, page 417. Then you see Rousseau Bound, Philosophy of Law, Chapter 3. You do not have time to read Chapter 3, you must read. So you will get this idea of separation of powers as it exists in theory, and the separation of powers as it exists and has remained in practice. Then during 90s, then the 20s, you have Rousseau Pound. Then nature of the judicial process by Cordoba unparalleled. There is no doubt about it. The more you read, the more you will find it. The nature of the judicial process by Justice Benjamin Cardozo, 1921 or 4. Then 40s, an article by Felix Frankfurter, Reflections on the Reading of Statutes, Columbia Law Review. That is an amazing article. During 50s, the classic debate between Professor H.L.A. Hart and, you must know the second name? Fuller. Lord L. Fuller. Yes, Hart-Fuller debate. That is published in Harvard Law Review, Volume 71, 1958. You have these, you have page 593, Professor Hart, and then 630, you have Fuller's article. Just after that, it is published. Separation of Law and Morals by Professor Hart and reply to Professor Hart by Fuller. I would say, if you don't read these, believe me, I will give you an example, then you will understand. Stealing is a crime. Tell me whether there is any element of morality in making it a crime, or it is bereft of morality. There is no element of morality. When we see somebody You have spent a lot of money in buying your t-shirt or your mobile. If someone will steal it, that it is already a crime. I'm not saying we are basically debating whether it's illegal, but what I'm saying is retrospective, making the exposed analysis. Does it have some element of morality, or is it devoid of morality? I would seek an answer. But is it necessary for every time to have some immoral content? This is basically what is about art student debate. That is basically about art student. We may take it up one day. We will take it up for discussion once you have basically read it. Professor Hart revised this is like in 58, this classic concept of law, 1961. Fuller later on 64. The morality of law, both published their work. Then some of these, you see, classic judgments, some of the classic judgments from Marbury versus Madison, Brown versus Board of Education, Texas versus White, Roe versus Wade, Lawrence versus Texas 2003, US versus Winter 2013, June 15 judgment of US Supreme Court, which goes alongside Lawrence versus Texas. In Indian, you see jurisprudence, that is the fundamental right case, the double suit case, especially Justice Khanna's, you see dissent for no other reason. I would cite this case. Or for some technical but historical reasons, cases under Bharati case. Some of these, on the international plane, judgments, reparation for injuries suffered, if you are asking post United Nations judgments, number of prior classic judgments, both by the Permanent Court and by the International Arbitral Tribunal, which will be Permanent Court of Arbitration or the interpretation. Number of judgments, these things we will discuss. Well, having said so much, being so critical of the Indian and national approach to interpretation, we have nevertheless what I did forward to you as the General Employment Act. But at a very cursory look, to say it is quite clear that it was never intended, nor it is to be a comprehensive code or interpretation. What it is basically, it has a number of provisions which it was intended because it was British, in fact, Act, and at that point in time it was not an independent country. The intention was wherever in all over colonies and wherever any British law, any Britain law, because post Bentham reforms in England, the trend is towards what we can say stratification. See, the common law, as you are very well aware, if you see the first page of Salmon, and you can see what Bentham used to say about common law. So you have statutes. So the intention was that wherever the statutes would be subject to interpretation, so whatever provisions are there, these would be interpreted in the same manner in which it is interpreted intended by the General Clauses Act. So it is a General Clauses Act, it is not the comprehensive code. It has been followed at least in the case that I forwarded to you, a very simple case. The idea is basically to see, to at least see 2 points. One is basically the less is the application of the General Clauses Act, but more from a very simple standpoint, the context in which problems of interpretation arise. The first is the concept of ambiguity. Anyone has heard of this particular term in the context of legality? ambiguity.
Which is not clear.
Which is not clear. Okay. Would everybody agree with this?
It can be there are two or more meanings from the same word.
So it is difficult to choose which one is to be preferred. So two equally tenable, you see, meaning more than one possible meaning of a term or an expression is ambiguous. Is it equivalent to vague? What is vague? If ambiguous is more than one, then what is vague? It's not clear. Okay.
Which doesn't provide the complete information. Doesn't clearly lay down the details.
Any other?
They are different. Ambiguity is something which give meaning but not single meaning. But we cannot derive meaning there. The exact meaning of the word of the whole context, which through the whole context is something cannot derive meaning.
Yes. Let me give you very quickly. Anyone you have referred to the abortion law case, James Murphy, Roe versus Wade case. Roe versus Wade case arises out of vagueness in law. But let me tell you, vagueness has not empirically been considered as a disease of the language, whereas ambiguity has been. Ambiguity is a poor reflection, is understood in a negative sense, is a demerit. And vagueness, many a time, intentionally by legislative and treaty measures, is the beauty of the language, because it gives you a range of options which may be equally valid. But let us come back to the point. The need for interpretation may arise, and we see does arise because of mostly because of vague and ambiguity. Let us get back to this particular point. You can see in the case that I forwarded to you. You can see this was out of ambiguity in the legislation. The ambiguity was any one of the directors, any one of the managers, any one, two separate words, any one, not anyone in the sense of pronoun. It is very interesting. The statute did not write anyone in the pronoun sense. It wrote in two expressions, any and one. Any one. So, the party was saying, one party was saying, it means one. You choose which one. You choose which one. But at the bottom of the case, it's only one. The other party is saying, if you are able to do this, choose one out of the several, it is going to be unconstitutional because of equality clause. So therefore, in order to survive the test of constitutionality, this literal interpretation, even if plausible, must give way to everyone. So anyone should become everyone. These are the problems. Sometimes, for simple words, like anyone may do. Anyone may do. Anyone may do. So the question is, in fact, the judges did not go, they did not apply the rules of grammar there. In fact, what they had to ultimately see was the constitutionality of their expression, their interpretation which they were giving. So sometimes there are vagueness, there are ambiguities in law. they are resolved by the court, not necessarily within the claims and the references of law which parties have made to support those claims, but also on the basis of an inherent judicial responsibility to apply the law, at least for the highest, and certainly mostly for the highest division in a constitution. These are the responsibilities of judicial, the responsibilities that you find. I would like to give you the time to reflect and respond with questions. I think half of the time should be given to you, or that is what I have in mind. Half of the time to respond. I'm not sure, but I intended that you read those readings so that you can actually respond. Those readings are certainly only one case to read, but conventions were there and more readings were there. Later, in classes, we will use more readings and more references. If you have no questions, which means that you don't find it to be shy of asking questions, that is the case. I don't think that graduate, post-graduate students, graduate in this country, undergraduate, post-graduate. So the point basically today is to know actually what you have done and what is going to be the outline, the structure of the course, the next series that they are going to adopt. We are not going to repeat what has been done, and mostly I believe even if you are not so explicitly stated to be, but I believe in countries like South Asian countries, the approach is typically common law and judge made law and one decision, and then it becomes a reference point for second decision and first and second. Ultimately, it is like it piles up. You have so much of case laws. You see practically in a court. So the lawyer is hardly going to see any standard. He would rather first find out the face of the judge. Oh, this judge could take his own ruling and then sign it. The best way to get your lordship, just last month you have done it. So this is the typical practical, and this is a very good way of putting it, but let me tell you, this tells you the true story. See, I have stated several cases here. This is how they do it. So this is typically, we are not going to repeat. You see, there is no point in, I have mentioned it elsewhere. You can read it. Some empirical assessment I have done it. Sometimes the testing of time, the cost of testing of time, but it was necessary. You see, by golden rule and literal rule, you see, it's very difficult for students to understand. Because sometimes you call it a literal rule, and sometimes you call that same literal rule a golden. So it's very difficult. You cite a case on golden rule, whereas the case is on literal rule. I give you a classic example. Gray versus Pearson. 99% books you read, they would cite it on golden rule. The case is on literal rule. You read it. The case says, the rule says, if there is a problem, if there is absurdity after reading the word, so you modify those words only to the extent of making sense. They cite Gray versus Pearson. You read Gray versus Pearson. There was no ambiguity. There was no problem of reading. There were two conditions on the basis of which the judge had to give judgment. One, that a person must die below 21 and die without an issue. There was absolutely no problem. Very simple language, of course. That particular language where English was written not without any comma, we have half a page or full 2 pages. That is really even commas and punctuation. They would not, decide. Sometimes, of course, you make a better common sense. So the common sense doesn't always become hostile to commas and punctuation. So that doesn't happen. So there is no point in referring to that. What we are going to do, we will certainly
points which are included in the approach of legal interpretation adopted at international level, codified in the Vienna Convention. We follow that approach, and within that approach, wherever we will find references to national jurisdiction, we will use those references. That is first. Second, we will also, you see, be representative of the application of Vienna Convention as far as possible. For instance, we would not merely refer to the cases decided by the International Court of Justice. We certainly make very good use of other jurisdictions such as World Trade Organization jurisdiction, Eastern American Court of Human Rights, European Court of Justice. Number of, you won't believe it, if you see EC Treaty, Article 234. This is the new article. If you are reading the old text, you read Article 177. You call it Article 234 within bracket X Article 177. You see, in this article, there is an inbuilt mechanism whereby the courts of national jurisdiction, national courts have been authorized to seek a preliminary ruling from the European Court of Justice if they have a case which necessarily involves application of EC law, but which, in the opinion of the national court, may not be applied consistently to the national law, because national courts ordinarily is a tax word, are organs of international law. They are not organs of international law. International law operates only if it is considered part of national law. So you can see this. You have from the Treaty of Rome 1957, you have gradual, you see what you say, Professor Weiler and others. What do you say? Deficit, sovereignty deficit. The sovereignty being gradually ceded from national level to regional, EC level. So more and more. So you have a number of cases. I mean, the list is endless. But we will pick up these certain cases. For instance, there is the celebrated case of Vandenloo case. That name that you want Jane Hughes, 1962. 1962 case. Or some other cases we will. So what we will do is make the use of these jurisdictions and employ the approach of Vienna Convention, including the approach of national jurisdiction, and would not see the approach to legal interpretation in isolation from one another. It's not that we will ignore the approach of Vienna Convention. It's not that we will approach the national. So wherever we will find the cases and refer to those cases, and readings will be given to you in advance. That is what post-graduate level of we used to get readings every day. Without reading, as always, there is no serious participation, because a lecture is not a monologue. Learning and knowledge generation is not a monologue. You have no means of verifying what I am speaking unless you have studied. And I also have no means of learning from you unless you have studied. So it's basically the mutual. You read. You have not read these two cases. I understand. Saturday you got it. Saturday you will get it only on Saturdays and Tuesdays. So after one class, you get next class. notes, but make use of, I would say, this is the Grand Coastal Board of Education, I'm sure you must read it. This is a classic. And I deliberately chose this. Why? Because it's a very simple case. Nothing can be more simple. It is a more simple fact that you have a set of facts again and again coming to the court where blacks, Negroes are made to sit in one class, or sometimes the Negro is deprived of a seat in a transport, sometimes just basically on the base of the color of the skin is happening again and again. Again and again we're going, and again the court is saying, what is the problem? That bus is also AC. That library also has the same books. Here they are the same, equal. Again and again equality was cited. See, look at it. Every time equality was cited. This is again, see, you read a book, Professor Dan Solution, he is a doctor. He wrote a book called Different Context. The point that I am picking up is from his point that he made. You see, the difference between a lumpen on the street and an institution like national court, superior court, is basically methodology of adopted to achieve the aim. The lumpen will beat you, abuse you, maybe keep you submit to them. But every time you see the 6 precedents, maybe, I think I am comfortable language than picking up to put out the point simply. Every time equality was cited, tell me, in any of these 6 cases, the petitioners were refused, they were saying he was not heard, we did not have a counsel. Or you see, you had every opportunity to put up your place. Every time. Every time they were denied of equality on the ground of equality. Equality was the ratio in all other cases. But the ratio in this case was separation. Judge says after separation, it is unconstitutional. There is no need to go further equality. You have separated. You have to point out the debate could be, if you really want to debate, you could debate, they were not similarly situated. If they were different people, then separation may be justified. But the point is, if they were same, the white colored fellow, the black colored fellow, same as white colored one, then separating them for the purposes of education, public education, for the purposes of transportation, is unconstitutional. So when something is irrelevant, the inquiry is complete. You don't need to go further. But what I am saying to you is this, the same equality was cited to deny these people, and you know how long? This is surprising. 1787. They got in the United States. 1858. 80 years. It took 80 years for them to get a loan. And look at it. They did not get equality. They only got a loan promising equality. 80 years to get a promise, a constitutional promise. Only a paper equality you got it. And then from 1858 to 1964, you got equality. In a country like United States. And this begs a question. I think Indians will be very happy. If this happens in the United States for so long, then why should we accuse Indian judiciary? But these are wrong references. Wrong reasons justified. Reasons sometimes, many a time people believe that if something is reasoned, something must be necessarily good. Conversely speaking, anything bad must be unreasoned. That is again a fallacy. That is again a fallacy. Oliver Wendell Holmes, when he was giving a talk to Boston College of Law, 1897, in part of your talk, he gave an expression, a sentence on logic that I find irresistible.
not to propose it. What he said was, logical method and form flatter that longing for certainty and for repose, which is in every human mind. But certainty generally is illusion, and repose is not the destiny of man. Behind a logical form lies a judgment as to the relative worth of competing legislative grounds, often an inarticulate and unconscious judgment. But it is the very root and nerve of the whole proceedings. You can give any conclusion a logical form. So the point is, it is sometimes a law student, the more he reads law, the more he gets to believe logical. Here you can see, every time you are deprived of your basic fundamental right on such a beautiful reasoning called equality. What can be a better reason than equality? What is the problem that? Maybe you will say, why are you breaking my head? The point is this, please, these are some of, that's not just not any other case. Now you see what, so much in this case, yes, there is so much in this case. So there is a sentence which Warren wrote, the very segregation of the same people, the very segregation brings a sense of inferiority in them that will never be undone. Wherever they will go, whichever field, they will believe that they are free. Because they were separate. They got high school exams separately, they got this training separately, they got this, even if they are the same. Where is that reason? But in that sense, we do not know what we are doing today. So this is what we are saying. So let us see. Sometimes we believe that the judgment was very logical. So logical, I would say, after you see, and believe me, he was the one who was the exponent of which school of jurisprudence? American realism. Yes, that's correct. Realism. Prophecies of what the courts will do in fact, and nothing more pretentious are what I mean by the law. That is exactly what, exactly this grey and disease. So the point is this, these are not certainty, you are not litigants. This is not history. But it is not for those particular facts, they are not interested in the outcome. Cases are taught in the class, students are no litigants. If that is the only justification whether you are interested in sources, no cases should be taught. If you are a litigant, you will get a much better experience of the law when you are a litigant than when you are a student. No matter how good a professor is who teaches law to you, believe me, you take one case to the court and you will have much better experience. That is not the purpose of citing cases in the class. The purpose is basically to learn for other situations. That case is gone. Whether it is this case or for that matter, much cited and sometimes much criticized case of certain expenses case by the International Court of Justice on the interpretation of the charter law, the property cases, you see the Nicaragua case, these are some of the Corfu Channel case, legal status of South Africa, interpretation of peace treaties 1950, factory at Togo 1928 or 7 Provident Court. These are some of the best known cases on any student of law, LLB, you will get, I'm sure, almost not, or they refer to at least, liberal and what do you say, extensive. Extensive is the word which is less. Liberal is the word which is most.
But when you see the operation of the same principle on the international plane, then you will see the whole horizon are different. Or when you read the article by Professor Lauterbach in the British Airbook on the same issue, then you will get it altogether different. The point is that merely by looking at one or particular national jurisdiction and because of it, you will only get an incomplete and unhealthy picture of subject. In order to understand the subject fully, you have to first adopt an approach which is far more representative, which is representative also of the discipline that you are student of, which is to widen it, you have to assimilate in it as many studies as possible, and then you see make use of this particular field, particular branch of law for your future pursuits. I would now really like to have your questions. Sir, you may have several questions.
Sir, in due course of our lectures, what are our plans? We'll first of all look at the principles of VCAT, principles of interpretation VCAT, and then also assimilate it along with the national principles of interpretation in national law, and then apply both the principles in the situations we confront.
You see, what we are going to do is this. For every class, we are going to give you readings. One reading you already have. Any reading that I have given will not be given again in the sense that it will not be, you see, attached to your name. But it will be cited so that you know that it is going to be relevant for the next class. So I am going to cite the Vienna Convention every time because I believe it is important. So you know that this is a reading. You will read the case, the cases that I am going to give you. Sometimes you find a case from ICJ, from ECJ, from WTO, from India, and on a particular theme. And then we will discuss and we will get, you see, what has been the experience of these different bodies alongside some, you say, very select secondary sources, but very few the questionnaire because most of them are not available in soft copy. They need to be freely available so that I can give it to you. So I will only cite it. Cases, these are documented mostly well. Cases, legislation, treaties are available, that's one of them. But secondly, we will look for that we will do. So we will make a reading and then we will certainly emerge better after. Let us say I gave you this point of literal versus liberal. So we will see friend, context for instance sometimes a very important element and very controversial element also. Because the question is the flexibility that a judge needs in order to settle a case, because of the two facts that the judge confronts every time, is also the source of problem. Let me give you a practical example. If you begin with the premise that there is a legislation which is a beneficial legislation, so it must be construed liberally. This is what we are told. The problem is this: before interpreting it, you have already made up your mind. So it is basically a question begging. Do you do interpretation after knowing the case, or do you do it before? Typical problem. Then, if there is a legislation which is not strict, legal legislation or a fiscal legislation, it must be construed strictly. Then again you find a judge in a different case, this is not an absolute rule. I will not follow it. He won't give you any guidance. Why won't you follow it? Presuming that it was correct to follow it. We are only saying, we are not saying that it was correct to follow it, or there is any yardstick by which Sometimes there is an approach saying that, well, the language is clear, disregard the consequences, gender time, but to Parliament intended to pay this much of tax, so that it is bad or good. Parliament will decide to bring in the CIC says that political parties are parties, public authority, so they all have a problem. So you have 2003 amendment already introduced, read it. Obviously, CIC says, well, this is not my problem, I got it, I gave it. You have a problem, you go to them. So they are doing it. But you know, even they have a problem, and when you have a problem, it makes a lot of difference. But that is altogether a different debate. We will touch upon these debates also. Once we have that, we will go beyond this also. We will also study it not from the standpoint of these mechanicals, otherwise it will be a very boring exercise, I am aware. So we will, you see, incorporate these. Wherever these points will come, we will take the debate to that level also. The level of rights, the level of democracy, civil whatever that we this is how we are moving forward. Very good question. This is the outline I hope it gave you more clarified. Any further? So you have to must have this.
So today I would like to give benefit of doubt to everybody. If we are not as well prepared as you should have expected from us, which is very legitimate expectation on your part. You would have made better use of this course today if you are ready. But I'm sure that I myself and my friends here, all our SAU law faculty family, will be better prepared for Friday's discourse by reading at least most of the material, if not the entire material that they will find. That means the following: that you read what you have said today, not today, for today's lecture, and also the thing that you are going to set for Friday's lecture. So I want to make all of us feel comfortable that if we are not as well prepared today, that does not mean that we are not going to be well prepared next time. So feel all of you comfortable, happy, and no grade is given on the basis of your preparation or lack of preparation for today's lecture. So time will come when you are better prepared, you can engage the speaker with more enthusiasm and with more queries than what we have been able to do today. Still, with a fundamental query I would like to present to all of us and to reflect on it, and that will help shape the scope of this lecture series. When we talk of law interpretation, we essentially talk of law interpretation relating to written law, statutes, legislation, constitution, enactments. If we confine our queries to that part of law which is written one, then probably we are leaving out a very large part of law which is applicable at both domestic level and at international level, that is unwritten one. It is possible to focus on law interpretation to written law, as it is law interpretation of statutes. But is it wise to confine ourselves to just focus on law interpretation relating to written law? Or in pursuit of a methodological soundness, we are engaging in substantive unsound policy of interpretation or understanding the law of interpretation. Fundamental question is, should we study law of interpretation by confining ourselves to law of interpretation relating to written law, or we should expand the scope of our study? That's one thing. The second thing is, when we engage ourselves in interpretation of written law, we often come across the questions of interpretation of unwritten law. Now, even if we want to confine ourselves to the law of interpretation relating to written law, we simply can't escape the question of interpretation of unwritten law in the course of interpretation of written law. This is very common at the international level. I can't say with great authority at a domestic level because one has to do a little more study. But this is very, very common problem at the international level, that you are presented with a responsibility to interpret written law, and then you ended up interpreting unwritten law. Now, let the rules of the game be clear right from the beginning in order to clarify the scope of the study. Are we going to begin with the understanding or whatever with the law relating to interpretation, confining ourselves to written law, or by necessary implication we include within it those incidental encounters where we are engaged with the interpretation of unwritten law? That is first step. Second query is, I'm sure you will come to that probably in some course. As I told you, the difficulty is that one should know the scheme, and probably you can clarify that scheme as you have asked and some others have in mind. The authority to interpret the law. As of now, we assume that the only institutions or the only persons who have authority to interpret law are judges, courts, judicial bodies, adjudicatory institutions. But the reality is, the truth of the matter is, that most cases or most incidents of interpretation of law don't reach courts. Most occasions of interpretation of law come by those very people who are in the business of making law and those who are close to the business of making law. Let's look at Right to Information Act, for instance. A very lively example in the current context. Assume that you have filed an RTI and reply comes that this is not within the purview of RTI, which is very common reply in RTI. I don't have again empirical evidence, but we have at least one limited experience which we did last year, where most replies were simply stonewalled or just completely denied by having one interpretation of RTI. Now, who is interpreting law here? Obviously, judiciary is not interpreting. Unless you challenge that interpretation or that response in the court of law, that interpretation will survive. The way equality debate or equality as a casualty survived in the United States. So it was not equality. Equality as a casualty that survived in the United States in the name of equality. The same way, the right to information as a casualty survives in this country as a right to information act as a casualty. I could see a parallel between the two. Equality was there in the United States, right to information is there in India, information is denied in India, the way equality was denied in the United States. I could see a very compelling comparison between the two. Now, until an authoritative interpretation emerges, you have a number of conditional processes of interpretation. They are conditional in the sense that they are invoked, they are pressed into practice, and they are not still considered as institutionalized, authentic processes of interpretation. Take for an example, you take a matter to the executive. A section officer responds to that matter by writing a note. That matter goes to the higher level, maybe director. Director is not bound by the interpretation given by the SO, section officer. It goes further. He may have whatever to add to that. Joint Secretary and maybe the highest level. It has not yet gone beyond the domain of that executive. The reality is that a large body of law is interpreted by the executive without creating or offering or seizing by anybody an opportunity to interpret that law through a judicious process and certainly not by a judicial process. Now, are we going to touch that aspect of interpretation, or we are going to leave out that aspect of interpretation because it is too messy an affair to understand what goes inside the functioning of a system of operation of the state in the interpretation of law? And I am particularly concerned about this matter from international perspective because in international system you rarely get an opportunity to have judicial or judicious interpretation of written law. Forget about unwritten. Now this limitation in functional terms is what worries me. How to reconcile our profound objective of understanding law of interpretation with this very formidable limitation that exists at the domestic level, but more at the international level. Opportunities and authority. I would love to see whether you have those factors included in your scheme, or probably I am expanding my wings too much and expecting too much, which needs more time than this limited period of about 8 or 9 lectures. That will make me to understand where we are going to move forward from here. Are we going to have a restrictive agenda of studying law of interpretation, or we have a broad agenda of studying law of interpretation? The scope of the study, what we are going to cover, that is precisely what I thought would help all of us to pitch our hopes and expectations, so that we can say with confidence that we have covered what we were